The final matter to come before the court this morning, which was scheduled for 11:30, is Hess et al. Versus Satink et al. It is now approximately quarter till noon. The appellee is here with counsel. Appellant counsel is not present. Appellee, you have 15 minutes to present your argument.
Thank you, Your Honor.
We've read the briefs, and we are ready to proceed in your.
May it please the court, my name is James McHugh, and on behalf of Gerald Hess and Mary Jane Hess, we are the appellees of this matter. I understand you've read the briefs. I can go through my arguments, or I can entertain questions as the court or as the panel would request. Basically, though, the appellant has 4 assignments of error, and on the first assignment of error, it deals with the issue that whether or not the trial court properly deemed requests for admissions to be admitted. And as we've discussed in our briefs, whenever a party fails to respond to requests for admissions in the time allotted by Rule 36, and as long as there is no extension of that time, the trial court basically must admit those or deem those admissions to be admitted, requests for admissions to be admitted. Thereafter, if in fact there is a motion or a proper proceeding to request the trial court withdraw certain requests, withdraw certain admissions, that needs to be filed with the court, and there needs to be, and that is with the court's, within the court's discretion to grant or deny that motion. In this particular case, the way the situation was is that the requests for admissions were served on January 28th of 2014. They were due on the 28th day of February 2014. A few days prior to the 28th day of February, actually there was a status conference with the court, and I agreed on behalf of my clients, and the parties agreed to give a 2-week extension on those requests for admissions to the 14th of March. As the record shows in my motion to have the request deemed admitted, I submitted emails to counsel on the 18th and on the 20th of March, and on the 20th I was told by counsel that he had been terminated by the defendant, and we filed our motion to have the request for admissions deemed admitted on the 24th. The order was granted by the trial court on April 9th, 2019. What's interesting, I'm sorry, 2014. What's interesting in this case, though, is that the defendant didn't do anything regarding those requests for admissions, i.e. did not ask the court for leave to withdraw them until after the plaintiffs filed their motion for summary judgment in early June of 2014. So on June 10th, I believe, the appellant, pro se, filed his various motions, one of them being requesting to withdraw what's deemed to be, or what's considered to be, a motion to withdraw his request for admissions. But in that request, this district has basically said that there was a 3-part test that the trial court can consider when concerning a motion to withdraw a request for admissions. One was under compelling circumstances that prevented a response. In this case, there were not compelling circumstances that prevented a response. The appellant had several weeks to respond to those. And frankly, the requests for admissions were pretty basic, and there weren't many. I believe there were 13 requests for admissions. Requests for admissions are some of the easiest discovery tools to respond to. You either admit, deny, or a brief statement. And many courts have ruled that congested work schedules, trial schedules, even illnesses are not compelling circumstances that prevented a response. In addition, the appellant tries to argue that he's pro se, and because of that he didn't know he had to respond or should have responded. And this court and all courts throughout the state of Ohio basically say that if a party proceeds pro se, he is still bound by the rules of civil procedure, and he's still bound to the court entries and the court rules, and he still must follow the proper procedure. So just because he's pro se is not a compelling or a circumstance that prevented his response. The second item was withdrawal of the request for admissions, or the admissions would aid in the presentation of the merits of the case, and there was no argument by the appellant that that would be the case. And thirdly, there was no prejudice. And in my position, our position here is that there would have been prejudice at that point in time. The case had been pending for 9 months or 7 months. We had requested these requests for admissions. We had passed the discovery cutoff date. Any dates to amend pleadings had already passed. The mediation date was canceled because no one showed up. And so there was indeed prejudice because we had already then filed a motion for summary judgment and waiting for a response from the court. And so the decision to withdraw admissions falls within the sound discretion of the trial court, and there's no evidence before this court that the trial court abused its discretion in denying that motion.
Counsel, I have a question.
Yes.
The letter from Mr. Satink has been referenced in the briefs.
Yes.
I'm assuming that's in the record before us.
Yes, it's attached to an affidavit from Mr. Hess, the appellant. You're referring to the August 22nd, 2013 letter that he
It's
sent?
the letter that accompanied the quote-unquote final payment.
Yes,
Okay.
yes. It was attached as an exhibit, I believe, in the either the first affidavit of Mr. Hess or the supplemental affidavit of Mr. Hess. And interestingly, there has been nothing in the record from the appellant that refuted anything that he said in the letter, on the record. So it's the appellee's position then that the trial court properly ruled that the requests for admissions were deemed admitted, and that the appellant's attempt to have those admissions withdrawn was properly denied within the sound discretion of the trial court. The second assignment of error is that the trial court, our position is the trial court properly granted summary judgment, and that reasonable minds could only conclude that there was a fraudulent transfer of part of the property in violation of Revised Code 1336. As way of just a brief background, Mr. and Mrs. Hess sold 2 parcels of property on Manchester Road to Mr. Satink back in several years before this, back in 2003. These 2 parcels of property included a small older building that was a small brick building that was used for offices, and then the other parcel included a much larger building that was a manufacturing facility. It was a much newer building, I believe, built in the 80s, and it had much larger, about twice or 2 to 2.5 times as much square feet. What Mr. Satink did was he transferred the major portion of the property into a trust. And of course didn't tell anyone, and he knew that, when he did that, he knew that by doing that he was going to try to attempt to keep that out of Mr. Hess from purposes of being able to collect on the mortgage and on the note. Even in the letter of August 22nd, there were claims by Mr. Satink that he didn't need that the only property that he would offer to give him back would be the property that's the smaller property of the 2 parcels. But again, it's clear from transferring the property to the trust, and then a month later, he sends this letter to Mr. Hess saying that he has no more money, he can't make any more payments, he's not going to make any more payments, and that then he forces Mr. Hess to call the note due, to accelerate it, to proceed with litigation. It's clear from the evidence before this court, and it's clear from the request for admissions that have been deemed admitted, that that property was transferred in bad faith and without any value being received. With the evidence that was presented before the court on this matter, again, the appellees maintained that the trial court properly granted summary judgment on that issue and ruled that the transfer of that property was fraudulent pursuant to 1336 of the Ohio Revised Code.
And then the order voids the transfer?
Yes.
Was that prayed for by the appellees?
I'm sorry?
Did the appellees request that?
Yeah. In our motion for summary judgment, yes.
Right. Okay.
Yes. Then in response to the third assignment of error, the appellees maintained that the court properly granted summary judgment for foreclosure, that there were no genuine issues of material fact left to be litigated Again, looking at the affidavits of Mr. Hess, the request for admissions deemed admitted, and from Mr. Hess's affidavit, the letter from Mr. Satink, it's clear that there is absolutely no evidence that the defendant put forward no evidence that refuted the allegations that he was in breach, that the amount of money that was due in fact, and that there's no basis for him not to have the mortgage accelerated and so forth. There's one element there that there was an attempt by the appellant to file an amended answer, but that was done again after all discovery had closed, after all time limits to amend pleadings had expired, and after we had filed our motion for summary judgment. It was also filed without leave, and there was no basis for filing the amended answer, and we filed a motion to strike, and that motion was granted by the trial court. So if you go back to the initial answer included no affirmative defenses that would in any way jeopardize the fact and the legal position that the appellees were entitled to foreclosure on the mortgage because of the breach of the note. The evidence clearly shows that there was a default on the promissory note, there was a default on the mortgage, that the amount of the note was accelerated. There's no question of fact regarding the delivery of the mortgage that was provided to the defendant, that the note was executed, the mortgage was properly executed. There's no question of fact that whether or not that the mortgage was filed because the mortgage was recorded in Sumner County, and there's no question of fact regarding who the holder was. Mr. and Mrs. Hess were the current holders of the mortgage. In addition, the admissions state that, and this is again in Mr. Satink's August 22nd letter, that there's $195,740.52 due on the note, that there are no further payments being made on the note, and that the note has a 2.5% interest and $100 late fee attached. So the trial court properly, there was no evidence to refute any of these issues, and there's no question of fact, and the trial court properly granted summary judgment on behalf of the Hesses on that count. And the final assignment of error put forward by the appellant is that whether or not the trial court properly awarded punitive damages and attorney's fees due to Mr. Satink's fraudulent transfer of the trust property. First of all, we maintain that the argument on this issue has been waived because the appellant failed to comply with Rule 53. The issue of the punitive damages and the attorney's fees was tried before the magistrate, and Rule 53 required that the appellant was to file objections to that within a certain period of time of 14 days. That did not happen, and when there was something filed late, there was no reason why it was late provided, and number two, the appellant failed to file any record, any transcript of the hearing before the magistrate or any affidavit regarding that hearing. So it's our position that this appeal, this aspect of the appeal had been waived with failure to follow Rule 53. In addition, there is no plain error because case law is clear that once a creditor demonstrates a fraudulent conveyance, that creditor may obtain both an avoidance of the transfer and an award of punitive damages and attorney's fees. And it's clear that the trust property was transferred. The letter of August 22nd, 2013 indicates that there is not going to be any more payments, and that the court properly then confirmed or affirmed the award of the magistrate. So with those positions in mind, on behalf of the appellants, on behalf of the appellees, we request that this honorable court affirm the decision of the trial court, affirm the summary judgment of September 18th, 2014, affirm the judgment entry of November 27th, 2014, where $195,740.42 was awarded plus interest and late fees, award the judgment of punitive damages in the amount of $50,000, and affirm the award of attorney's fees in the amount of $9,738, for a total amount of $255,479. I would also like to, and I believe I said this in our statement of the case, that no stay of execution was granted by the trial court, by this court, and the decree of foreclosure, as this court might recall, there was a first appeal filed that was later dismissed because the entry of the trial court was not final. The trial court then issued a final decree of foreclosure on February 20, 2015, and that's the order that prompted this appeal. However, there was no stay of execution and the property was sold on April 10, 2015. There was a confirmation of sale filed, order filed on 5/29/2015, and then later an amended confirmation of sale order was filed on June 23, 2015, and there has been no appeal from either one of those orders. So on behalf of Gerald and Mary Jane Hess, we respectfully request that the trial court decisions be affirmed.
Thank you.
Thank you.
Thank you for your presentation today. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. We are adjourned until next Tuesday.